NARISYAH, our senior counsel. We are from group number 1 and we would like to present our case file number 4 titled The Insider 1999. I will first begin the presentation by an introduction. A good corporate governance can be known as a system of laws, customs, and procedures that a company is governed, managed, and operated under. The relevant statutes discussed pertaining to this matter is basically Companies Act 2016 and Malaysian Code on Corporate Governance. The main criteria on a good corporate governance mostly refers to transparency and accountability. In order to be transparent, the information about the company's operations, governance structure, and decision-making procedures must be timely and accurately disclosed. Besides that, accountability entails the procedure to make sure that management and board members operate in the company's and its stakeholders' best interests. Apart from that, a corporate disclosure is known as a process of informing a company's stakeholders about its financial performance, operations risk, governance structure, and other significant issues. Corporate disclosure is important as it functions to provide transparency, assist stakeholders in making knowledgeable decisions, and foster stakeholder confidence in the company. Basically, in Malaysia, corporate disclosure attempts to ensure that the companies give stakeholders accurate and transparent information so they can make sensible choices. For the purpose of our discussion, our group has been assigned with a case study, case file number 4, where it required us to provide a discussion on a movie titled The Insider 1999 and specifically to present on any misconduct or contravention of the law in respect of good corporate governance and corporate disclosure done and committed by companies and parties involved in the case. Under this case file, our discussion will begin on presenting the synopsis of The Insider 1999, followed by explaining the issues highlighted in this study, the laws and principles, and we will be presenting on our analysis in regards to the laws and principles that are related to this assigned case file.
The Insider 1999 is a movie based on real events that revolves around the efforts of a corporate whistleblower, which is Jeffrey Wingen, a former head of research and development and a corporate vice president of Brown and Williams Tobacco Company. After being fired from his job, Wingen is bound to the confidentiality agreement that prevents him from revealing the inside information about the company practices. Noel Bergman, a producer from the investigative news program 60 Minutes, becomes aware of Wingen's potential of the explosive knowledge about the tobacco industry and approaches him to persuade him to share his insights. Wingen is initially hesitant due to legal repercussions that he could face, but eventually agrees to cooperate with Bergman. As Jeffrey begins to disclose damaging information about Brown's and Williams' antics to Bergman and his teams, the tension starts to escalate. The tobacco industry has taken legal actions, and due to these legal actions, Wingen starts to face legal actions, threats, personal attacks, and even surveillance, and this actually leads Leanne, Jeffrey's wife, to request a filing of divorce due to the struggles in the situation. Since the situation entwined Wingen's life is seemingly irreparable, it drove him to finally deciding to speak his truth, as it was not fair for him and his family to be treated that way by Brown and Williams. Meanwhile, CBS faces its own set of challenges. Bergman clashes with his colleagues in CBS who doubt his story's worthiness, and CBS executives makes extra effort to bury or downplay the revelations. Bergman and his team persist in their investigation, working tirelessly to gather evidence and corroborate with Wingen's claim, which is the addictive nature of nicotine in the manipulation of tobacco ingredients. At last, the broadcast sends shockwave throughout the country, igniting public outrage and triggering lawsuits against the tobacco companies. Hence, The Insider concludes a poignant reflection on personal sacrifices made by Wingen and Bergman in the pursuit of truth, emphasizing on the importance of journalistic integrity and the power of standing up against powerful interests.
Before signifying the related laws, issues included are whether Jeffrey is still bound by his duties as a former director and can be held accountable even if he is the previous corporate vice president of a tobacco company. Second, whether Jeffrey has violated his duties as a former director, particularly in the context of a breach of confidentiality, by disclosing the truth to Lowell Bergman. And lastly, whether a confidentiality agreement can be breached for the sake of the public benefit.
Next, I will be discussing about the laws relevant in this movie. Firstly, under common law, the fiduciary duties of director include to maintain the confidentiality of the company's information. This is because director often have access to sensitive and confidential information about the company, so director must not disclose or use confidential company information for personal gain or in a manner that could harm the company's interests. In other words, they have an obligation to safeguard this information and take reasonable measures to ensure its protection from unauthorized access. Next, it is also pertinent to mention here that this duty extends even after the tenure as director has ended. Secondly, the director has the duty to act in good faith and in the best interest of the company. This duty requires director to make decisions and take action that prioritize the welfare of the company as a whole rather than their own personal interest or the interest of any specific shareholder. Furthermore, acting in good faith means that the director must approach the responsibility honestly, with integrity and without any intention to defraud the company or its shareholder. Moving on to the statutory law, which is under Companies Act 2016, Section 21A is applicable here. This section basically discusses about prohibition against improper use of property and position. Specifically, this section prohibits a director or officer of a company from using the property of the company information acquired by virtue of their position as a director or officer, any opportunity of the company, or engaging in business in competition with the company to benefit themselves or harm the company without the consent or ratification of a general meeting. This provision also aims to prevent director and officer from using their position for personal gain at the expense of the company. Next, pertaining to the breach of confidence in general, a breach of confidence by a former director of a company occurs when they disclose or misuse confidential information obtained during their tenure as a director. In regards to the violation of non-disclosure agreement, if the former director had signed non-disclosure agreement with the company, their breach of those agreements would constitute a breach of confidence. All in all, a person who has access to confidential information is under a duty of confidentiality, which means that they cannot disclose the information to third party without the owner consent. In discussing about the duty of confidentiality, this duty originates from the case of Kuku and A.N. Clark Engineers Limited. In this case, the court established that there are 3 elements necessary to establish a cause of action for a breach of confidence, which are the information was of a confidential in nature. This means that the information must not be available to the general public or readily accessible to people that normally deal with that kind of information. Next, it was communicated in the circumstances importing an obligation of confidence, which means that it must be reasonably made clear to the recipient that the information was imparted in confidence. And lastly, there must be an actual or unauthorized use or disclosure of the information in question. In regards to the public interest defense to breach of confidentiality claim, this defense has not been raised in any Malaysian case on claim for breach of confidentiality, but the defense has been accepted in defamation cases. This defense is a legal concept that allows individual or entity to justify the action or disclosure that would otherwise be considered breach of confidentiality based on the belief that the action were necessary for the welfare of the public. In other words, it can be said that this defense serves as a balance between the duty of confidentiality and the potential harm that may arise if certain information remains hidden. Following that, there are 2 cases that discuss about this defense, namely the case of Attorney General and Guardian Newspaper Limited and others, in which the court said that although the basis of the law's protection of confidence is that there is a public interest, that confidence should be protected by the law. Nevertheless, the public interest may be overwhelmed by some other conflicting public interests that promote disclosure. Similarly, in the case of Sharing Chemical Limited and Fortman Limited and others, the court mentioned that the public interest defense is applicable only when the topic or content is harmful to the public interest or pose a threat to individual safety.
First of all, by applying the common law on the fiduciary duties of a director into this recent case study, Jeffrey Wigan, as the former head of research and development and corporate vice president of Brown and Williamson Tobacco Company, was bound by his fiduciary duty to maintain the confidentiality of a company's information. As a matter of fact, Jeffrey Wigan should not disclose confidential company information and he must safeguard such information. Despite being fired by the company, the duty imposed on him still extends even after his tenure. However, in the movie, Jeffrey Wigan disclosed the confidential information of the company, knowing well that such disclosure would cause harm to the company's sale, while the company could lose its customer. Therefore, it could be said that Wigan has clearly breached his fiduciary duty as a former director. Next, Jeffrey Wigan is also bound to the fiduciary duties as a former director to act in good faith and in the best interest of the Brown and Williamson Company. He should be prioritizing the welfare of the company as a whole and not his own personal interest. In this movie, Wigan decided to disclose the confidential information to CDS due to his personal, financial, physical and mental pressure given by the company as well as encouragement by CDS. Thus, his action give nothing beneficial to the company's interest itself but damages. Therefore, it could be said that Wigan had not acted in good faith and in the best interest of the company, making him breach another fiduciary duty as a former director again.
pursuant to Section 218 of the Companies Act 2016 and applied to Wagen cases. By virtue of Jeffrey Wagen's position, he shall have acquired a lot of confidential information in the company. Thus, Wagen is prohibited from using such information to benefit himself or harm the company. In this movie, at first, Wagen is determined to disclose the confidential information of the company because of the money offered by the CBS, since he was unemployed and he lost his source of income. Here we could say that Wagen has used the confidential information for his own benefits. Only later, when Wagen received death threats from the company, which also involved his family, Wagen got devastated that he became more determined to disclose the information as revenge for the mess given by the company to him and his family. Here we could say that Wagen has used such information to harm the company. Thus, Jeffrey have breached his duty as a former director of Brown and Williamson if it is to be discussed under Section 218 of the Companies Act 2016. In this movie, it shows that Jeffrey Wagen has signed a confidentiality agreement with Brown and Williamson Tobacco Company during the commencement of his tenure as the director that governs his duty and obligation. During his tenure, Wagen has access to every information about the company as he was the head of research and development and corporate vice president, which was meant to be confidential. Thus, Wagen is under a duty of confidentiality, which meant that he should not be disclosing the information to CBS without the company's consent. In this movie, Jeffrey Wagen disclosed some of the pieces of information he knew during his tenure as the director of the company in his interview with 60 Minutes and testified himself as the witness for a lawsuit against the company in Mississippi. This has led to the breach of the confidential agreement between himself and the company, which constitute a breach of confidence. In addition, by applying the crucial elements necessary to establish a cause of action for breach of confidence, as well in the case of Coco against AN Cloud Engineers Limited, the information disclosed by Wagen in this movie can be said to be very confidential in nature. This is because such disclosure could cause harm to the company in the sense that the company has a high probability of losing its sales. Secondly, disclosure of confidential information by Jeffrey Wagen are communicated in the interview of the show 60 Minutes, which will be aired to the public, so it can be said that it is in the circumstances imposing an obligation of confidence. Lastly, such disclosure of information by Wagen is considered as unauthorized, as no consent from the Brown and Williamson was obtained and it was in breach of their confidentiality agreement. Considering all elements established, Jeffrey Wagen is said to have committed a breach of confidence in this case. Overall, Wagen is seen to be held accountable for his action. However, this movie plot has also included an element that could be a defense to Wagen's action that could exclude him from liability, which is public interest. In this case, it was stated that Brown and Williamson Tobacco Company, a company that sells tobacco, has ignored the health consideration consciously when the company manipulates and adjusts the nicotine fix. Such ignorance for the sake of sales could be a ground for a public interest where it could justify confidential information to be disclosed publicly. By applying the general principle of public interest defense to breach of confidentiality claims into instant case as the misconduct of the Brown and Williamson Tobacco Company could cause harm to the public, Wagen can use this as a ground to justify his action of breaching the confidentiality agreement with Brown and Williamson and disclose such information to the public in 60 minutes, as it is believed that his action were necessary for the benefits of the public. If the information remains hidden, it could cause more harm to the public, as there can be more probability for more consumers to get killed by the dangerous ingredients used by the company. Hence, the principle of public interest defense could be applied to exclude the liability of Wagen in this case against the company. Moreover, applying the quotes in the case of Attorney General against Guardian Newspaper Limited and others, and Sharing Chemicals Limited against Faulkman Limited and others, the public interest in this case may be outweigh the confidentiality because it threatens the life and death of people, thus it favors disclosure, justifying the action of Wagen for disclosing such information in 60 minutes as necessary disclosure, even though it could cause him breaching his duty as the director and confidentiality agreement with the company.
Junior counsels, we concluded that there were indeed misconducts committed by Brown and Williamson and CBS. This is obvious that the principle of corporate governance and company disclosure has been violated, and owing to this, the company's adherence to moral principles and its duty to its stakeholders deserve to be called into question by this lack of transparency and accountability, which also jeopardize the benefit and health of the public. Hence, it is only relevant that Jeffrey took the initiative to disclose the bitter truth to the public concerning the tobacco company that was only driven by financial gain. After considering all issues in this movie and complying with the law and cases, it is our viewpoint that Jeffrey is not accountable due to consequence where even if he did violate his duties as a former director, especially since he had signed a confidential agreement, under the common law, he is deemed to have breached duties, but applying the defense of public interest, Jeffrey is excluded from being liable. This is in line with where a confidential agreement can be breached for the sake of the public benefit, as if the truth remains hidden, it will threaten the safety of the public, which includes the life and death of the consumer. Therefore, while it is important to not take the confidential agreement for granted, corporations must ensure that they comply with the principle of corporate governance and company disclosure in the first place, so any harmful and illicit business in nature will not occur. A recommendation that can be made is to strengthen the whistleblower protection laws and encourage more NGOs' involvement in protecting and encouraging. We believe that this type of protection can encourage more people to act bravely just like Jeffrey, and at the same time put a curb on a company that deals business in dangerous manner, which in this movie to avoid Brown and Williamson from acting supreme and running the business in a dirty way.